Nullification, the rightful remedy. Of all the different tools to rein in the federal government, this is one that's very prominent and also somewhat controversial. The idea that a state can say no. I want to get into some of the history of nullification in our country, but first we're going to talk about a more general topic, that of interposition. Now these words are sometimes, especially in the founding era, used somewhat interchangeably. Interposition literally means to interpose, to stand between. Generally, it means you're putting yourself in harm's way to protect someone else against a danger that's threatening them. Interposition is a great, very broad topic. And many things that fall into the topic of interposition are nullification. But there are many other things as well. I'm going to start off with a story from this book known as The Doctrines of the Lesser Magistrates. And in this story, this goes back to the year 39 AD, in which Emperor of Rome, Caligula, basically declared that he is a god, and as a god, he should have an idol of himself, a statue, built and placed in the Jewish temple in Jerusalem. Now, how well do you think that went over with the Jewish people of the time? Oh, not well at all. Yeah, absolutely. They were so concerned about this. This would desecrate their temple, literally. And they were willing to fight and die, if necessary, to try to stop this from happening against legions of Roman troops. Yeah, good luck with that. And yet they still pled with their local ruler. Their local ruler's name was Publius Petronius. He was the governor over that area. And their pleadings to him and recognizing the justness of their cause really touched his heart. And as it says here, he refused. He actually wrote back to Emperor Caligula and said, "We're not doing this." They did have the statue made. And here's the interesting thing. Publius Petronius called 2 legions of Roman armies to come together and stand before the temple with the Jewish leaders on the opposite side, which I'm sure was quite intimidating to them. And then he came out and stood between, physically demonstrating this act of interposition, showing and explaining to them that these troops are here under the order of Caligula to force this upon you. And I am going to use my position as governor here to stop it and put my own life on the line. He even goes on to say, paraphrased, "I shouldn't think my own life so important that I wouldn't be willing to sacrifice it to preserve your rights here." Now, he wasn't even a Jew. Every time I tell that story, it amazes me that he was willing to put his life on the line to defend the rights of these people as this intermediate level of government, as the local governor. Now, I'm sure Caligula took it very well, right? He demanded his death. He sent a letter to Publius Petronius, demanding that he have himself executed. And just after he sent that letter, calling for the death of Publius Petronius, the palace guard killed Caligula, and a second letter was sent on a faster ship. And that second letter, that Caligula is dead, got there first. And then he gets the letter from this now deceased emperor that no longer mattered. And that saved the life of Publius Petronius. The reason I start here is because I want to illustrate the level of character that we need in public office, that are willing to put themselves on the line and interpose when necessary to prevent the rights of the people being abused. That is well demonstrated in this story. He literally was willing to put his life in jeopardy rather than violate the sanctity of the temple, which he didn't even believe in. It's amazing to me. But we see similar acts of interposition with our own founding fathers. For example, the Declaration of Independence, my favorite part of it is the conclusion. and for support of this declaration with a firm reliance on the protection of divine providence, we mutually pledge to each other our lives, our fortunes, and our sacred honor. Anyone that knows much about history knows that many of them did pay with their lives and their fortunes, and all of them put their honor on the line and were maligned as traitors to the crown, and worse, because they too were willing to interpose, to put themselves in harm's way to prevent the destruction of our rights as a people. They stood between. Classic example of interposition. So interposition, historically, we could point to a lot of things as acts of interposition. The Magna Carta really was an act of interposition. The Boston Tea Party, Declaration of Independence, we mentioned, interposing. Really the entire American Revolution, as it's often called, or our war for independence, are all acts of interposition, putting them in harm's way to protect our rights. Now, as we go to the more narrow definition of the term nullification. Nullification, first of all, I want to talk about what it's not. Nullification is not sedition, rebellion, or secession. And it's also not begging. It's not pleading with the federal government, please, can we have our rights? It's taking a bold stand and saying no. Regardless of getting any permission to do so from the Supreme Court or federal government anyway, what it really is, it is enforcing constitutional laws. Not enforcing, but resisting laws which have no constitutional authority. It really is upholding and defending the Constitution. And as such, it is very constitutional to uphold the Constitution, right? I mention that because some people claim nullification is unconstitutional. We're going to get into the evidence of that today as well. And the first place I'd like to go is the Federalist Papers. What are the Federalist Papers? They're essentially letters to the editor of the state of New York newspapers from three men, Alexander Hamilton, James Madison, and John Jay, advocating here is why we should adopt this new proposed Constitution from 1787. Because they knew that the state of New York was a real swing state. If we get New York on board with this, then the likelihood of this Constitution being adopted is great. If not, it'll probably go nowhere without New York. And so they went through in 85 letters explaining different parts of the Constitution and how it should work if implemented. This has been looked at by our courts, including federal courts, the Supreme Court, and so on, as official explanation of the meaning and intent of the Constitution, repeatedly for over 200 years now. Is that a good source to look to understand what the Constitution says and means? Absolutely. It's one of the best. And so as we look at what did they say we should do, because they addressed this many times, what should we do if and when the federal government oversteps its bounds? That was one of the more common topics addressed in various Federalist Papers. I'm going to touch on a few of them here. And it really falls into two categories. The first category is the role that we, the people, have. The ultimate redress, the means of opposition are powerful and at hand. This is kind of leading up to what are they going to tell us to do? Madison says, Federalist 44, the people who can by the election of more faithful representatives annul the acts of usurpers. What does that mean? We have the power to vote. We all know that. We don't ever want to underestimate that power, certainly. We need to have elections. We need to have elections we can trust in, for sure. But if we felt like that's our only power, we're going to feel pretty powerless, honestly. I've heard often said, oh, you just got to vote harder, right? Kind of mockingly. There are more tools than just that. The next one I really like, partially because of the choice of words. Madison says, the disquietude of the people is an important power. How many times do you use that word disquietude in your daily conversations? Pretty much this is the only time I use it, is when I'm quoting Madison, Federalist 46. What does it mean? Disquietude. It literally means the people are beginning to speak out against, if you're an elected official, they're beginning to speak out against your actions as an elected official. The more disquietude you have in your district, the more your chances of re-election are going down. Does that mean anything to them? Well, certainly it does. And in fact, I'm going to touch briefly on this topic of disquietude, even though that's not really the focus of today's presentation. There are a couple other points I want to make. First of all, usurpation requires the concurrence of the courts of justice and the body of the people. When the federal government is usurping power, it's only because we, the people, tolerate it. And then my favorite quote on this screen is this one, and this one comes from Hamilton. A little background on Hamilton for a moment. Of all the founding fathers, if we were to do a political scale, you have someone like Jefferson, who's very, very limited government, very conservative, and on the opposite end of the scale, we have Hamilton. Hamilton was the one who, in the convention of 1787, suggested, this is getting to be really difficult, trying to come up with our own form of government. Why don't we just model our new form of government after the British one and have our own king? That was Hamilton. He was the big government guy. So when I show something from Hamilton, you'll often hear me say the phrase, even Hamilton understood this. Even Hamilton advocated this. The big government guy. So in that context, even Hamilton says, constitutional enforcement by the people requires what? A people enlightened enough. I want you to remember that phrase. A people enlightened enough. To do what? To understand the difference between what is and what is not constitutional, is what he's saying next. And then, when we are that people, we are as the natural guardians of the Constitution. Pause there for a moment. What did he just say that we are? The people are the natural guardians of the Constitution. Wait a minute. So if our nation's off track and we're not following the Constitution, whose fault is it? Right? We, the people, the natural guardians of the Constitution, have not been doing our job properly. How can we if we don't know the Constitution? We have to be a people enlightened enough. And then I love the language he uses here. As the natural guardians of the Constitution, the people would throw their weight into the national scale and give it a decided preponderancy in the national contest. Great, I love it. I love the way they spoke at the time. What he's saying is, ultimately, we the people are the highest power in the land, and when enough of us speak out against what the government's doing, they will back down. We do have a tremendous power there. I'm not going to spend more time on that. I have an entire presentation on the topic called The Power of 500, which explains how, a few years ago, in a matter of just a few months, gathering together less than a team of 500, we were able to get our congressmen to go from following the Constitution about half the time to almost always, just by voicing our disquietude. And we could call that the power of disquietude, but it doesn't have quite the same ring to it. But that is what this is about. How to speak out in a way that gets your elected officials' attention enough to get them to start voting better, start following the Constitution. Because honestly, if we were doing this in every congressional district around the country, Congress, for the most part, would be following much more strictly the Constitution. But the topic today isn't so much what we the people can be doing, but the topic of interposition and nullification. And so with the topic of nullification, this is literally, and going back to the title of the book, The Doctrine of the Lesser Magistrates, it literally means a lesser magistrate is someone in an intermediate level of government power. They're not the highest power like Caligula was. And they're there to protect the people from the abuse from above. So in this topic of nullification, again, we jump into the Federalist Papers. These two really go together. For Madison, schemes of usurpation will be easily defeated by state governments, who will be supported by the people. And state governments with the people on their side will be able to repel the danger. So now we have a responsibility on two fronts, don't we? The state governments have the responsibility to defeat schemes of usurpation. When the federal government oversteps its bounds, how many of our state legislators and governors know that that's their job? To be defeating usurpation of power on the federal level. But notice the other part in here is who will be supported by the people. I think we're back to the responsibility on us again there, aren't we? Because we have not been holding our state level officials accountable for how they defend the Constitution. They haven't been doing it very well. And yet, it's so clear. Again, even Hamilton advocated this. Check this out. If the cooperation of the state legislatures be necessary to give effect to a measure of the Union, they have only not to act, or to act evasively, and the measure is defeated. What is Hamilton advocating here? That is what I would call nullification. When a state simply says no. Do you know that the vast majority of federal programs require the state's help to implement them? Exactly what he's talking about here. When I was on a speech tour in Texas a few years ago, Governor Abbott had recently come out saying, I really support this idea of the 10th Amendment and separation of powers and things, but the 10th Amendment has no teeth. So we need an Article 5 convention to give some teeth so we can push back against federal incursions. And when I went on a speech tour, local media came to me and said, well, Governor Abbott just came out against what you're saying. You're here speaking against the Article 5 convention. Do you have a message for Governor Abbott to answer his question there? I said, yes, I do. I have 3 words for Governor Abbott. Stop being complicit. Because even Hamilton understood this. Even Hamilton understood that, Governor Abbott, you have the duty to say no to the implementation of unconstitutional federal programs. What an idea, what a concept. Madison says this even more concisely, the concept of refusal to cooperate with the officers of the Union. And he takes it a step further. The state should also be presenting legislative devices that present obstructions to the federal government, giving obstacles to them implementing federal law, which historically sometimes even includes the threat of imprisonment of federal officials. Yes, that's happened on a number of occasions in our nullification history. One of my favorites, though, this has to be my favorite of anything Hamilton ever wrote. Again, even Hamilton, when he talks about federal laws that are not pursuant to the Constitution, federal laws that are not constitutional, but which are invasions on that authority, these will merely be acts of usurpation and will deserve to be treated as such. What is he suggesting there? If you're treating a federal law like it's an act of usurpation, it means you're not recognizing any authority in it. We're going to come back to this quote a little bit later here. I love that one. That was a key point in the topic of nullification. Even Hamilton advocated it. Now, really the first major time of advocacy on a national level for nullification happened in response to the Alien and Sedition Acts of 1798. Among other things, these included things like, it's now illegal for you to speak out publicly against the actions of the President or Congress. Does that sound like it might be violating the Constitution in some way to anyone? Yeah, seriously. And interestingly, at the time, the president and vice president weren't on the same ticket. Whoever got the most votes became president. Whoever got the second most became vice president. So we had Thomas Jefferson as vice president at the time, who was the odd man out. The president and Congress were of one party, and he was the other party, and so he was kind of just cast aside. So when they created the Alien and Sedition Acts, you can say anything you want about the vice president. You can't speak out against the president or Congress. And in response to this, Jefferson and Madison drafted the Kentucky and Virginia resolutions of 1798, in which they advocated for the idea of nullification. And this is really the first time we see in any major way nullification being pushed on the national level. And some of the things they wrote about this are very clear and very monumental in this topic of nullification. For example, he says, the several states who formed that instrument, the Constitution, being sovereign and independent, have the unquestionable right to judge of its infraction. What's he saying so far? The states created the Constitution. They have the unquestionable right to judge whether or not the Constitution's being followed. It's their contract. And that a nullification by those sovereignties, those states, of all unauthorized acts is the rightful remedy. Okay, so what's he saying? States have the right to judge? Wait a minute, really? Today we're taught who gets to judge whether or not something's constitutional. The Supreme Court, of course, they're the only ones, and they have the final say. It's almost as if we come to believe that the Supreme Court is superior to the Constitution, which is absurd because they also swear an oath to uphold it, which would mean they're under it, not over it. But anyway. And he goes on to say, without this right, the states would be under the dominion absolute and unlimited of whosoever might exercise this right of judgment for them. That's why it's so dangerous to believe that only the Supreme Court can possibly understand and tell us what the Constitution means. Every elected official is supposed to understand it and enforce it themselves. Continuing, Madison, a couple of years later, Report of 1800, was another time where they go into more detail on this topic of nullification. He says if the states could not interpose, there would be an end to all relief of usurped power, as well as it would be a, check this out, a plain denial of the fundamental principle upon which our independence was declared. What did he just say there? He just said that the very concept of our Declaration of Independence was an act of interposition, and if you're telling me the states don't have a right to interpose, you're telling me we also had no right to declare our independence. What are you, some kind of British loyalist? And so anyone, even today, that is advocating this idea, we don't have the right to interpose, to nullify, is really on that side of tyranny of the British loyalists in that time period. Further in the Report of 1800, in case of deliberate, palpable, and dangerous exercise of their powers not granted by the Constitution, the states have the right and are in duty bound to interpose. The reason I mentioned that one specifically, this isn't just an option. This isn't just, they have the right to do it if they want to. They have the duty. Our state-level governors and legislators, and even your county level and every level of government, has a duty to uphold the Constitution when it's being violated. Let's get into that a little bit deeper, because why do they have that duty? Because they swore an oath of office. Who swears an oath of office? As it says in Article 6, Clause 3 of the U.S. Constitution, it requires senators and representatives, state legislators, judicial officers. Basically, what this comes down to is everyone in any level of government, whether they're elected or appointed, whether it's military, sheriffs, police, any level of government, is required to swear an oath of office to the U.S. Constitution. Well, that's interesting. Why? James Madison answers that question. What does the federal Constitution have to do with a governor or a state legislator in a state? The members and officers of the state governments will have the essential agency in giving effect to the federal Constitution. They're there to make sure it's enforced. Even if, and I would say especially if, the federal government is not. When the federal government is overstepping their bounds, that's when your oath matters. It's to stand up and say no. So going back to Madison's previous statement, they are in duty bound by their oath of office to interpose. Now, what does their oath say? Unfortunately, I feel one of the biggest problems we have within the states today, especially state legislatures, they seem to think their oath of office is something like this. I do solemnly swear that I will be subject and subservient to the federal government. I will support and defend all laws passed by Congress or the Supreme Court or the President or any of the federal agencies, because they all get to create law, right? Never questioning their authority to legislate in all matters whatsoever. In practice, that seems to be what so many elected officials think their oath of office is. What is their oath of office? What do they actually swear? They solemnly swear or affirm, I will support and defend the Constitution of the United States against all enemies, foreign and domestic. And I would assert the biggest threats to the Constitution are those domestic ones, the ones that are seeking to subvert it from the inside. So, we have Article 6, Clause 3, the oath of office requirement, that they're all duty-bound by oath to defend the Constitution, but then we also jump to Article 6, Clause 2, the Supremacy Clause. Now, they want you to believe the Supremacy Clause says, this Constitution and the laws of the United States which shall be passed by any federal branch shall be the supreme law of the land. That is not what it says. And the difference is key, because it doesn't say any laws that are passed by any federal branch. It says laws that shall be made in pursuance thereof. What does that mean? Laws that are made in pursuance or in following the Constitution. So laws that are made in following the Constitution are supreme. What does that tell us about laws that are made that are not following the Constitution? This brings us back to that quote I shared earlier from Alexander Hamilton, Federalist 33. Laws that are not pursuant to the Constitution are merely acts of usurpation and deserve to be treated as such. So what we have here is two clauses in Article 6. The Oath of Office Clause requiring an oath, a duty of every level of government to defend the Constitution, and a defining of that is only the Constitution and those laws in following the Constitution are supreme. Packaged together, the vast majority of the things the federal government's doing are in violation of that standard. This is why I refer to this as nullification is the Article 6 solution. Our elected officials, sworn by oath in Article 6, Clause 3, and upholding the true meaning of the Supremacy Clause in Article 6, Clause 2, have the duty to nullify unconstitutional federal law. I find this next quote quite an interesting one I ran across a few years ago. Daniel Webster tells us, "It will be the solemn duty of the state governments to interpose between their citizens and arbitrary, unconstitutional power. These are among the objects for which the state governments exist." What did he just say there? The whole reason we still maintain this state-level government structure, we didn't just create one national government that oversees everybody. The whole reason we still have state governments is for them to interpose, for them to stand between, for them to nullify, to protect the people and their rights against federal tyranny. I think it's time we need to remind a number of governors and state legislators why they're even there. Now let's get into some myths. The first one, nullification is extra constitutional. I see that promoted a lot by those who don't want us to be doing nullification. Some scholars out there are saying, well, it's outside the Constitution. And is it? I think we've pretty well covered. Article 6, Clause 3, oath of office requires nullification, guided by the true meaning of the Constitution, as defined by Article 6, Clause 2. That's very much in the Constitution, that requirement to obey, sustain, and defend the Constitution against usurpation and abuses. Absolutely, that is in the Constitution. Nullification was used to protect slavery. And interestingly, scholars have looked in the history of nullification, not found any examples of that, but they have found a number of examples of nullification being used against the unconstitutional fugitive slave laws, for example. We'll get into that in just a moment. The next one I want to touch on briefly, though, is Madison opposed nullification. I've seen this one introduced a few times where, oh, sure, Madison may have advocated nullification back in 1780 or 1798, 1790, and so on. Sorry, it was 1798, yeah. But later in life, he changed his mind. Is that true? Let's look at the history. So first of all, here's some of his 1798 support that we've shared before. They have the right and are in duty bound. You remember that quote? There's a little more to it because he mentions this is to preserve the Constitution. That's the purpose of interposition or nullification. But sure enough, we do find this quote from 1834 where he says, nullification has the effect of putting powder, kind of referring to gunpowder, putting powder under the Constitution and the Union, and a match in the hand of every party to blow them up at pleasure. What did he just say there? He's comparing it to like putting a gunpowder bomb underneath the Constitution and the Union, and anyone can blow it up anytime they want to with nullification. Sounds like he's speaking against nullification, doesn't it? Did he change his mind on nullification? Those who oppose the Constitution being enforced by nullification will often use this quote without sharing any of the context, and that's key. Do you know what the context of this quote is? What type of nullification was he opposing? That's the question. If you ever see someone share this quote with you out of context like that, that's the question to ask them. Well, what type of nullification is he talking about there? And there's a key in that document, in that letter, just a few paragraphs later, he says he's referring to this offspring of the discontents of South Carolina. There's a little bit of a clue there. What was going on with South Carolina at that time? Calhounian nullification. This was in response to the nullification crisis of the 1830s, which was a response to the Tariff of Abominations, they called it, where there were tariffs imposed that were really hurting the economy of the South, especially South Carolina. And in response, John Calhoun led this charge saying, we have the right to nullify. And they terribly misused the whole concept of nullification in three major points. It was the bizarre theory, as Madison put it, that South Carolina could, number one, they could nullify a trade tariff. Do trade tariffs have any constitutional authority? Yeah, they do. So strike one, they could nullify a trade tariff. Nullification was for unconstitutional acts, according to Jefferson, Madison, and others. And number two, in so doing, South Carolina could block the entire Union from observing this tariff. States don't have the right to tell their states what to do, right? And that would remain in effect unless and until the states gathered in a convention, and with a 3/4 majority vote, they overruled the nullification of the tariff. What's that based on? There's nothing in the Constitution that says anything remotely like that. So they made this one up. This is quite a strange distortion of the concept of nullification. Can you see why Madison was saying that this is like putting powder under the Union and a match in every man's hand to blow it up at pleasure? This literally, if we feel like this is a just use of nullification, any one state could say we're going to shut down the entire operation across the entire country of anything we want to until 3/4 of the states say otherwise. That would be chaos, wouldn't it? That really would. And interestingly, just a few months later, same year, December of 1834, Madison went into much more detail of his opposition to Calhounian nullification by first endorsing Jeffersonian nullification. By quoting Jefferson at first, he quotes Jefferson saying, where powers are assumed which have not been delegated, every state has a natural right, in cases not within the compact, to nullify. And then Madison adds his own commentary. Thus, the right of nullification meant by Mr. Jefferson is the natural right, which all admit to be a remedy against insupportable oppression. And then he takes on the topic of Calhounian nullification in the very next line. It cannot be supposed for a moment that Mr. Jefferson would not revolt at the doctrine of South Carolina, that a single state could constitutionally resist the law while remaining within it, and that a cession of a small minority and others overrule the will of the great majority of the whole and constitutionally annul the law everywhere. The key is, can one state block a law across the entire Union? Well, that's absurd. Nullification is within a state. If one state says, we are not implementing this law, that happens within that state. If the neighboring state says we're going to go along with it, that's up to them. Each state is sovereign in that way. And the reason he's pointing to Jefferson is that Calhoun was pointing to Jefferson's writing saying, Jefferson advocated nullification, we're going to use it too. He's saying that's not Jefferson's nullification. Did Madison change his mind about nullification? Not at all. He consistently supported Jeffersonian nullification, but very strongly spoke out against Calhounian nullification. And when it comes down to nullification, I would conclude this one thing. There's really only one reason to oppose nullification. You don't want the Constitution enforced. And there are people on a number of different movements out there promoting that idea. The Article 5 Convention movement, for example, they often oppose nullification because it competes with their movement. We don't want another option on the table. We got to look like we're the only hope. If you start using nullification, we don't have any justification for an Article 5 Convention. That's some of the most prominent nullification opposition I see lately, is those that want to change the Constitution through an Article 5 Convention. I'm going to conclude with a few examples of nullification in our nation's history. Starting with the Fugitive Slave Act, I mentioned we get to that a little bit. Fugitive Slave Act of 1850. There are some interesting details of this. the Fugitive Slave Act was unconstitutional. I'm just going to say that from the beginning. It violated the concept of due process. If someone was accused of being a runaway slave, it actually specifically forbade them from testifying in their own behalf. Can you believe that? And if somebody else, if a white person came along with a black person and said, he's a fugitive slave runaway and I want to take him back to my state, the testimony of the white man prevailed. They even included in the Fugitive Slave Act that if the judge who's overseeing the hearing of this rules in favor of this being a fugitive slave and sends them back, they get paid twice as much for their services as if they ruled that he's not a fugitive slave. There's actually a financial incentive to send them back as a fugitive slave. There were a lot of problems with the Fugitive Slave Act of 1850. And rightly so, 13 northern states nullified, passed laws saying we will not be helping implement and we will even block the implementation, the enforcement of the fugitive slave laws. One in particular I'm going to point out here, this one's quite interesting. In Michigan, for example, it mentions that every person who shall not allow due process in the determining if somebody's a fugitive slave, which the Fugitive Slave Act blocked, if you don't allow due process, you'll pay a fine not less than $500 nor more than $1,000, and you will be in prison, there's no option here, 5 years in state prison. Who did this apply to? First two words, every person. Whether they're a state government agent, whether they're a federal agent, that took some courage, didn't it? For state government to declare to the feds, we will imprison your agents who come into our state and try to violate due process in extradition of fugitive slaves. I love the boldness, and that's why I share this. The boldness of the story I gave at the beginning, Emperor Caligula and standing up to him. The boldness here, we will imprison federal agents. We need some of that boldness today. The one I'm going to share next is the Real ID Act of 2005. The Real ID Act has been on the books for about 18 years now, and it's still not in effect. Why? Because when it was first passed, there was a big uproar from the people against it. This is a huge invasion of our privacy. And I won't go into all the details of the Real ID Act, but 12 states declared they will nullify the Real ID Act. This will not be implemented within our state. And they even said that it is a felony if any of our state officials help implement any aspect of the Real ID Act in some states. In Montana, where I lived for a while, for example, and I find this interesting, the Democrat governor who had spoken out against nullification signed the nullification of the Real ID Act because there was enough groundswell support. He had to look like he was the leader of this championing the cause and so on. I love that. So 12 states stood up and said no, and at that point, the federal government backed off. Said, okay, we're going to extend your implementation deadline a little further here. And by that point, 28 states were saying no. Where are we now? Well, at this point, pretty much all the states have buckled. Just this last week, as I was going through TSA, I see this sign. Be your Real ID self. Be ready by May 3rd, 2023. Now, I've been flying on the airlines for a number of years, and I've seen that same type of sign for more than a decade. But guess what? A decade ago, it didn't say 2023. It said 2013. And then 2016 and 2018, they kept moving that implementation deadline further and further and further, hoping that eventually they could persuade, bribe, or threaten the states into compliance. And that's pretty much where we are now. If only the states recognize the power they have, though. I love this article from Cato. This is back in 2015. They declared, guess what, states? Yes, they're bribing and intimidating you. You never have to comply. As long as the states continue to say no, the federal government doesn't have the political capital to enforce this, and they never will. So we've kind of lost this battle now because we are to the point where the states have been either bribed or intimidated into compliance, and it looks like it probably will go into effect in 2023. But it didn't have to. It's time to remind our state legislators of the power they truly have and the duty they have to protect us against unconstitutional violations. The word valor, to me, really applies here. Because this isn't just a normal legislative duty, is it? This is something that takes courage. Maybe not to the same degree that Publius Petronius did, where they're going to get, you're now commanded to execute yourself. But it does take some courage to stand up to the federal government. We have this mentality in our states that they're just subjects and subservient. Remember, I talked about that. What does valor mean? Strength of mind or spirit that enables a person to encounter danger with firmness. It's personal bravery. So when they're nullifying, it takes a certain degree of courage. I recognize that. But today is not a time for people in political office who are timid. And the greatest threat to our liberty is not in the Middle East or in anywhere else in the world. It really is in our state capitals in Washington, D.C. I'm going to conclude with this great quote from John Dickinson, founding father. If you comply, you fix, you rivet perpetual chains upon your unhappy country. The time to nullify is now. The time to stand up boldly against the federal violations of the Constitution is now. It's not just the right, it is the duty of every elected official to do so. Thank you.